Are you a parent involved in a child custody case in juvenile court and your case is before a magistrate and you don't know what a magistrate is and you're wondering how that can affect your case and what you can do if you don't like the way the magistrate's handling your case? Well, my name is Patrick Slaughter. I'm a family law attorney with LaFevor and Slaughter. We're a family law firm located in Northeast Tennessee, and I'd be happy to answer that question for you. A magistrate is someone that the judge who has been elected has appointed to assist them in administering or taking care of their caseload. So what happens is typically you'll have a jurisdiction where there's a great number of cases and it would require more than one judge. Well, instead of electing more than one judge, the legislature has given the judge permission to appoint. In other words, the judge says, hey, I want to hire you to be a magistrate to help them with the cases. This person is a lawyer. They typically have a great deal of family law experience and particularly a lot of juvenile law experience. And they're appointed by the judge to handle cases just like the judge would in their stead. Now, what can you do about it if you don't like them? Well, just because you don't like them doesn't mean they may not be good at their job, and it may not mean that they're making the wrong decision. So first, before you let personal feelings like that come in, I would ask you to reevaluate those. Don't let this become a personal issue because it may not help you and it may hurt your case in the long run. Generally, magistrates are doing the best job they can with the information they have, and they're not prejudging your case or other cases because, frankly, they don't know you and they have a whole lot of other cases to get through. But that doesn't mean they don't get it wrong sometimes. And if they do, you have an option. You can appeal their decision directly to the judge. You have that right. There's state case law and there's also state statute that provides the procedure. You have to, within a certain number of days, generally 5 to 10, depending on the circumstance, but you want to appeal that magistrate's ruling to the elected judge, and the elected judge can take your case up and you can start all over if the judge so feels. But you should be aware that a lot of times judges have a lot of confidence in the magistrates they've appointed, and sometimes they just what we call rubber stamp whatever the judge or the magistrate says. And that doesn't necessarily help you in the long run. Sometimes they don't, but a lot of times they do. The other thing you should consider is, depending on your attorney's relationship with the court, your attorney might be able to go and say, hey, this isn't really a good case for this magistrate. Judge, can you agree to take this on your own? Of course, they'd have to do that in the presence of the other attorney because we're not allowed to talk to talk to judges by ourselves. We have to have the other side present. But if folks agree, then judges will typically want to take that up. But at the end of the day, if we're in juvenile court and the magistrate does something we don't agree with and we appeal that to the judge, the elected juvenile judge, and the juvenile court judge doesn't agree with us, if it's a dependency neglect case, we can appeal that directly as of right to the circuit court judge. If it's a child custody case where there hasn't been any allegations of dependency neglect, then we can appeal that to Tennessee Court of Appeals. It depends on the type of matter it is. And all these things are fairly complicated, but if you have these issues, I would encourage you to pick up the phone and give us a call. Let a seasoned attorney talk with you and talk over those options. We might have some insight as to the court, maybe even the magistrate or the judge, and give you some information about how you might want to consider your path forward. But as I said earlier, in the meantime, don't assume the worst. Don't awfulize. A lot of folks do that. But put your best foot forward and try to impress the judge or the magistrate with how cooperative you can be and prove your case, because that's what it comes down to. In the long run, you just need to prove your case or make sure the other side can't prove theirs. That's what's going to do the best to help you win whatever kind of matter you're in. So I hope this helps. Good luck, and I'll hopefully talk to you soon.